Good afternoon, everyone. Thank you for joining us. My name is Leslie Orloff, and I direct the National Immigrant Women's Advocacy Project at American University Washington College of Law, and I'm staffing the National Judicial. We staff the National Judicial Network. So I'd like to welcome you all here today. This webinar is sponsored by, next slide please, by the State Justice Institute, and we want to thank them for their support. And we're going to start by introducing right now the people who are going to be presenting at this great webinar today. Let's start with Bill Tamayo. Bill, you want to introduce yourself?
Yeah, sure. Hi, I'm Bill Tamayo. I'm the regional attorney, or excuse me, I was the regional attorney for the EEOC in San Francisco for 20 years, directing the litigation. In the last 6 years, I've been the district director overseeing investigations and operations. And I've worked with Leslie off and on for almost 30 years on these various issues.
Yeah. Thanks, Bill. Mary?
Hello, Mary Tiernan. I'm the Outreach and Education Coordinator for the EEOC's Philadelphia District Office. Our district covers all of Pennsylvania, Northeastern Ohio, West Virginia, Delaware, South Jersey, and Maryland through our offices in the district. And I'm very honored to be here today. Thank you.
Jane.
Hi, I'm Jane Anderson. I'm an attorney advisor with Equitas. We're a nonprofit dedicated to providing training and technical assistance to prosecutors and allied professionals that are handling cases of domestic violence, sexual violence, stalking, and human trafficking. And we've been proud to partner with NUOP for years now. And so thanks for having us.
You're welcome. Commissioner Young.
I'm Loretta Young from Newcastle County Family Court in Wilmington, Delaware. I've been working with Leslie for I think 6 years now. I've been involved in trafficking concerns for about 12 or 15 years, and doing some specialty court calendars that really sometimes are not entirely populated, but heavily populated with cases that are suspected trafficking.
And I'm Leslie Orloff again at NUOP. I was involved in drafting the VAWA self-petition with Bill Tamayo, the U visa and the T visa later on. And we have expertise, NUOP has expertise in the legal rights of immigrant survivors of human trafficking, domestic violence, sexual assault, child abuse, and do training and technical assistance nationally. So I want to welcome you all here today. I want to start the webinar, next slide please, by talking about the National Judicial Network that is sponsoring this webinar. We have funding from the State Justice Institute, and it is a membership network of judges, commissioners, tribal judges, magistrates, and other judicial officers that are committed to the effective adjudication of cases involving human trafficking victims and/or immigrant crime victims. Obviously, trafficking is a broader category, can include US born victims as well as immigrant victims. And so our trafficking work encompasses adults and children, immigrants and citizens. And then in addition, we specialize as a group in issues that arise in cases of immigrant victims of domestic violence, sexual assault, child abuse, elder abuse, human trafficking, and other types of crimes, mostly violent crimes. The network develops trainings and provides peer-to-peer training opportunities on a once-a-month basis among judges and judicial officers. And so those of you that are judges or judicial officers who are joining this call and would like to join the network to get the monthly invitations to the monthly meetings and the materials updates, et cetera, you can click the link here to join the network, and we'll be sending it out to those of you that work for court systems and judges who are judges after this webinar. Next slide, please. Currently, we have the network is made up of 130 members, including 92 judges, 7 magistrates, 7 commissioners, 16 tribal judges, 6 retired judges, This picture gives you a little bit of a picture of the our current geographic reach of the network. And again, we welcome those of you who are judicial officers to join us. Next slide, please. We're going to start off with a poll to get a sense of who's in the audience. So if you could click the category that applies to you, and for those of you that click other, please explain in the chat who other is, like what are the other categories who are on the card. I want to get a picture of who's here. It looks like we have, I have to do quick math, just around 50% of you, maybe a little higher, looks like it's going up, are either judges, judicial officers, or court staff, law clerks, which is our key target audience. There's about 53% of you that are saying other, and it looks like we have U.S. Attorney Office, victim witness, psychologists, people working with victim advocacy, and the like. So thank you for joining us today. Next poll, please. We're going to, the next poll is going to look at, I'm trying to get my poll to go away. So next we want to ask you, have you encountered, for those of you, we want to start off with whether or not in the cases you've handled, have you encountered a victim of labor trafficking or someone who you suspect may have been a victim of labor trafficking in any of your court cases? And I'm not seeing the poll, maybe I shrunk it. Is there a poll coming? Oops.
So the poll is launched and people have answered it. If you can't see it, I can just read you the results.
Yeah, that would be great. I think I minimized the wrong one.
Okay, so it looks like right now we have about 32% of people said yes, 40% said no, and 27% said I'm not sure.
Okay, great. I mean, that's a good place to start. I mean, I'm hoping that those of you that are saying I'm not sure, that this webinar will give you some more tools to feel more confident about being able to identify labor trafficking victims. And as you will hear from many of our presenters, when we first started this work, many of us now, after learning about labor trafficking, realize that we've seen this in cases before we knew what we were looking at. And that's what this webinar is all about. So I'm going to start by turning this over to our first presenter today, who's going to kick us off, Jane Anderson from Equitas.
Thanks, Leslie. I want to make sure we get some foundational information. These are going to be really quick labor trafficking basics, since that's the focus of what we're going to be talking about. This is an act means purpose analysis of federal labor trafficking laws. State labor trafficking laws do differ, but usually we see a lot of commonalities. And if you're more familiar with sex trafficking laws, you're going to see those sort of familiarity as well, especially when it comes to the act. You know, recruit, harbor, transport, provides, obtains benefits financially or by receiving anything of value. The purpose being forced labor, forced services. We'd have other language that's a little bit archaic at this point, but we're looking at debt bondage, involuntary servitude. Want to take a minute to look at the means. We usually talk, and sometimes it's just shorthand, we talk about force, fraud, and coercion. Federal trafficking laws do use different language. So force, restraint, threats of harm, abuse or threatened abuse of the legal system. So right away, we should be thinking about threats of deportation. And then this last one, which is really the definition of coercion, which is any scheme, plan, or pattern intended to cause the person to believe if they don't do it, they're going to suffer serious harm or restraint. So what's missing from that list, right? So when we think about the shorthand, we always think about force, fraud, and coercion. And you'll note that one of those was not really enumerated there. So no, you can put it in the chat, or we'll just go ahead and give you the answer. And that's fraud. Fraud is not one of the listed ways to do that. Great job. Somebody came up with it in the chat. And I think that's because we don't want to be over-inclusive when it comes to labor trafficking. right? So merely, having a bad job or having one promise that's not fulfilled is probably not going to get us to labor trafficking. But of course, fraud in the context of a scheme, plan, or pattern is going to rise to that level of coercion. So coercion is defined as those threats, those things that we talk about all the time, the things that are probably going to be most obvious to us. And then the other side of the slide, we're thinking about abuse or threatened abuse of the legal process. And then this middle piece, which is really sometimes where the rubber meets the road, because it's usually not one fact, one silver bullet. It's going to be a pattern, a scheme, or the plan. Often fraud is going to be part of that. Let's look at the next slide where we really kind of go down into what does serious harm mean. And this I really want to point out because it's very specific that when we talk about serious harm, we are talking about things that are not physical as well of course, physical harm. So we're talking about psychological harm, financial and reputational harm, right? If these are sufficiently serious enough, we can get to this level of serious harm. The other thing I really want to point out is that although we talk about this as a reasonable person standard, the language in the definition allows us to, and you can really encourage us to take an individual approach to each case. It talks about a person in the same surrounding circumstances, a person of the same background and all the same circumstances. And the next slide shows us a couple of cases that really point that out. One of the seminal cases says, you know what, we have to look at each victim's vulnerabilities because those vulnerabilities are going to be relevant and when we make our determination of whether that coercion rises to the level of serious harm. Likewise, in the second case here, Kalimlum, excuse me, they really go out of their way to say, you know what, the threat to this victim, which was, we're not going to send money back to your family in your country of origin. For this victim, that threat was a serious harm and the defendants knew that. And therefore it rose to the level of coercion. So we really do want to be making an individual analysis when we look at what amounts to serious harm in the context of forced labor. So there are a couple of things I wanted to point out. In the federal definition of forced labor, there is no sort of carve out exception for minor victims. So those of you that have done sex trafficking work, we know that if the victim is under 18, we don't actually need to prove the force, fraud, and coercion. Yes, we want evidence of it. We want to present it in court, but it's not an element of the offense. That is not the same for the federal definition of labor trafficking. So even with minor victims, you're going to make that element of proof. Some states have carved out that exception for minors. I worked in Florida prosecuting sex and labor trafficking in Miami for several years. And we had, once we updated our statute, we did have a carve out for minors involved in labor trafficking. However, just put a bookmark there, which is that if you're looking at continued presence or T visas, that the circumstance has to rise to the level of the federal definition, not your state definition. So we've got a question. Yeah.
Go ahead, Jane.
I was just going to pass it off to Judge Young.
So what might state court judges include in court orders to help children prove the means by which they were trafficked? Anybody has some idea what to do with my orders? I want to add a lot of detail. So I don't want to just say, based on the evidence, I find by preponderance that this was a violation of 1052. So I want to explain and include in my order what exactly were the facts that I found. So later I'll have a jockey case that I talk about. I would include, the child was forced to work. And how he was forced to work, and include other details. And I don't even really need to indicate in my order that I found it was labor trafficking. but I would include all of the facts so that this order could be secure for whatever purpose.
Great. Back to you, Jane.
So one of the things is, always looking at those vulnerabilities, and we have a ton here. We talk about poverty, lack of opportunities, family obligations. Oftentimes victims of labor trafficking, that is probably their heaviest weight, is that they may have come to this country with sort of the weight of their family's expectations and livelihood on their backs. And so to be able to leave a bad situation doesn't really feel possible to them. So lots of other vulnerabilities, including substance use disorders. Of course, labor trafficking happens to US citizens as well. A lot of those examples include victims that have mental or physical disabilities, those that have criminal histories and aren't able to find work through the normal circumstances, or those that have substance use disorders. So when we look at the totality of the circumstances, we want to look at the type of harm, remembering that that's a very broad way to look at serious harm. We want to look at all of the surrounding circumstances, and then we really want to look at who the victim is, where they came from, what are their circumstances. We know that traffickers use individual tactics to actually control victims. What button is going to be the right button to push. And so we need to also be looking at that when we're building our cases. So where do you think labor trafficking happens? So feel free to use the chat as you're thinking about these things. I think some of them come to mind really, maybe at the forefront, and then others are not as commonly thought of. So research around all trafficking is always something I want to caveat, which is this is something that is underreported, identified. So any research is probably something that we need to, look at critically. But the research that we have does show some prominent high-risk venues. A lot of you in the chat have been identifying them, right? Agriculture, love it. Clara says everywhere, right? Parks, gas stations. We've had a couple of cases that happened in gas station, like little convenience stores, factories, warehouses, massage parlors, hotels. I haven't seen a tattoo place yet. That's an interesting one. Domestic workers. Okay, so the big reveal, based on some really seminal research that was done out of the Urban Institute with Colleen Owens, who is a regular contributor to a lot of this work. You'll see that the number one place of incidence is in private residences under domestic servitude. And you kind of see what you guys all picked out, which agriculture next, some restaurants, hospitality, constructions. But this is changing. This research is now even, from 2014. So we've seen definitely an increase in reports out of assisted living, sales crews. There was a case we'll talk a little bit more about, which is about forced panhandling. Interestingly, they are pretty gendered. So you'll see male and female victims trafficked in different venues at different higher rates. You'll see some people that have been trafficked through multiple venues. And these are some of them also sex oriented. So you'll see some crossover with strip clubs and massage parlors as well. So I'll pass it to Bill.
Okay. So good afternoon to everybody. And again, I want to thank my video's on. So I hopefully you're seeing my screen. You're seeing me.
Yes.
Okay. All right. So again, good afternoon to all the judges and to all the participants. So my name is Bill Tamayo. I direct the EEOC's investigations and operations in Northern California, Northern Nevada, Oregon, Washington, Alaska, Idaho, and Montana. And before that, you can do the next slide. I was the regional attorney where I directed all the litigation in that jurisdiction. And I also covered Northern and Central California, Hawaii, Guam, the Mariana Islands. But before that, I actually practiced immigration law, a lot of deportation defense, and worked with Leslie on the self-petitioning provisions of the Violence Against Women Act. So I come to this from basically essentially as a deportation immigrant rights lawyer, and then also as the civil prosecutor for the EEOC on discrimination cases. So let's start with a poll. What forms of relief can the EEOC obtain for victims? And poll should pop up. Leslie, I'm seeing you in my screen, right?
You're seeing me? Oh, okay,
Yeah.
I can. I'm seeing I can do this. So we're seeing that essentially 94% of the people, or the high 80s, 90s, are saying all of the above. Some people are saying back pay, some people are saying reinstatement, a little less. A few more people are saying compensatory, and some people are saying punitive damages. But nobody's saying termination of the harasser except for the people that say all of the above.
All right. Is that the end?
Yep.
Okay, so you're right. All of you got that answer. Who said all of the above? You're correct. Now, Jane's earlier poll showed that a lot of the labor trafficking cases might fall into agriculture. And I just wanted to point the irony of the fact that you were doing this training right after July 4th holiday. But July 4th, when the nation was more or less founded on July 4th, we also know our nation was founded on labor trafficking in the form of formal slavery, indentured servitude, again, arrests and putting blacks into chain gangs so that they could be the workforce for agriculture and also for city projects. And then we also made sure they were more vulnerable because Congress denied them protections under the Fair Labor Standards Act and the National Labor Relations Act. So it's not surprising that for the EEOC, many of our cases and egregious cases come from agriculture. So the main law we're going to talk about is Title VII of Civil Rights Act of 1964, which prohibits discrimination on the basis of race, color, sex, national origin, religion. This is the main statute that we've been dealing with in the context for the EEOC of cases that have trafficking elements in them. And sexual harassment, primarily rape of farm workers, is a big EEOC priority, and we have litigated many of these cases across the country. Like most federal statutes, Title VII prohibits retaliation. The other statutes we enforce, next slide, is the Americans with Disabilities Act, the Age Discrimination and Employment Act, and the Equal Pay Act. So, as you noted earlier, the remedies, next slide, for harassment or retaliation are pretty much you get your money back, you can demand your back pay if you're fired or demoted, get you back your job if you were fired, get money for your pain and suffering, your emotional distress, get you punitive damages if the employer acted with malice or disregard, and then if you're retaliated against as a witness, etc. Then we try to put in and get other injunctive relief, which may include terminating the harasser, bar future hiring, change the way the company responds to harassment complaints, train the supervisors, etc., and so forth. These are the traditional remedies that we get. So why I'm laying this out to you is while there may not be a criminal case, there are certainly civil remedies that might be available. One of our first big farm worker cases, and this was litigated by my office, was EEOC versus Tonamora and Antle, where a farm worker was forced to have sex with the hiring official on 2 different seasons in order to pick crops, just so that she could feed her 3-year-old daughter. And when she refused, another time, these other supervisors were harassing her, grabbing her, propositioning her. She went to the office to complain, and she was thereupon fired. She went to California Rural Legal Assistance and asked them not to complain, not about sexual harassment, but said, can you help me get my job back? I was just fired. But in that case, we found out from, case was referred by CRLA, and we found out that she had to perform sex in order to get her job. And when she refused opposed further harassment, she's fired. we investigated, made a finding against the company, and more or less we settled the case with a complaint and consent decree in 1999 for almost $2 million. This kind of broke it open for the EEOC nationwide for getting farm worker cases. A few years later, we litigate EEOC versus Harris Farms. Next slide, please. A rape case, multiple rape cases where Olivia Tamayo was raped at gunpoint 3 times. And after each rape, the harasser said if she told anybody, he would kill her husband. And so Olivia understood if she reported her husband might be killed. And if she told her husband would kill Rene Rodriguez and he'd end up in the in prison. Her husband would end up in prison for years, and she'd be a single mother then with 5 kids. So she held it in, didn't tell anybody until nearly 4 years after the last rape. We managed somehow to still litigate that case. And it's featured in a Frontline video called Rape in the Fields. It's also featured in Ms. Magazine. I would recommend to anybody, please see Rape in the Fields, just Google that, and you can get right straight to the video. That was followed up the next year by a case out of our LA office against Rivera Vineyards, where several women were sexually harassed. One was raped. Company settled for $1 million. Moreno Farms came out of Florida, where 2 sons raped these women. 5 women and 1 woman had been simultaneously raped by both sons. Jury came back with a $17 million verdict. Our LA office also litigated a case. This was not a agricultural case, but it was a janitor case. Next slide, please. EEOC versus ABM, where 21 Latina janitors were sexually harassed. If you could move it to the next slide, please. 21 were sexually harassed. 1 had been raped. The company eventually settled the case for $5.8 million. There is a companion video called Rape on the Night Shift. And you can Google that and you get straight to the title. Could you move it to the next slide, please? Okay, and then just a few years ago, we settled a case of egregious sexual harassment and national origin harassment targeting Latino workers in Mississippi at Koch Foods. And they were all fired. In all of these cases, everybody's fired. And that's why the workers finally come forward to complain. They don't complain while they're still working and sexually harassed, but they'll come forward after they've been fired. So we settled the Koch Foods case for $3.75 million. For me, the early indications of labor trafficking came, next slide, please, in 1997 when I made my first trip to the Northern Mariana Islands. And I became involved in a case where 2 Filipinas had been recruited to work in a nightclub. And they were told, oh, you're coming to the United States, but they were really in Northern Marianas, which is a territory of the United States. And after 3 weeks, they were told, hey, in order to keep your jobs, you ought to have sex with, you have to work the back room, the VIP room, which basically was to have sex with the local politicians who went there. They opposed it, and the women were terminated. I met these women on my first trip. We took their charges, we investigated, found other women, and eventually obtained a $350,000 judgment against Moods and Music. And we prosecuted that case with the help of the U.S. Attorney's Office in Guam. Then the next case really showed elements of labor trafficking was DeCoster Farms, where 10 women were trafficked from Mexico to work in poultry farms. I had received a call from the Iowa Coalition Against Domestic Violence, where Sonia Para Conrad, the staff attorney, calls me up frantic and says, hey, we have these cases in Iowa. Can you do anything for us? And I contacted my counterpart in Milwaukee at the time, Gene Camp. I said, Gene, you got to jump on this, contact Sonia. And just when, Gene is about to send a team of attorneys and investigators down to Iowa, the company knows we're coming down, and the company targets the women and says, if you cooperate with this federal investigation, we're going to fire you, further harass you, and have you deported. Gene had to run into federal court to get a TRO to block all that. so that the women could cooperate. We had investigated the case, concluded that the women had been raped and sexually harassed, and then the company eventually settled for 1.525 million. This was also featured in Rape in the Fields, but note here, there was no criminal prosecution. And if you look at Rape in the Fields, the sheriff who investigated these cases is fit to be tied as to why there was no criminal prosecution here. Next slide, please. In John Pickle Company, another clearly trafficking case, Asian Indians were recruited from India to work at a sprinkler manufacturing company outside of Tulsa. They were held in bondage. They only had one. They were held in a warehouse. All these bunk beds were in there. They only had one bathroom. There was no heating. This was wintertime, terrible living conditions, and they couldn't leave the compound until one day they're allowed to take a walk, and they pass by a church, and one of the workers says to a churchgoer, "Please help us. We need help." And that eventually gets some authorities to start looking at it. Our EEOC office in Dallas sued John Pickle. And here we alleged national origin discrimination. That is, the Indian workers were treated differently from the non-Indian workers. That's the discrimination. And they were treated differently in their living conditions, et cetera. And we got a $1.25 million verdict. And then again, no criminal prosecution there, even though the criminal law enforcement authorities were aware about it. And then in Trans Bay, our LA office sued the company that was making parts for the San Francisco Bay Bridge in LA. And the workers were held in terrible living conditions, their passports stolen, they weren't paid their wages. Our office sued again on using national origin discrimination and obtained a $1 million settlement. Then our biggest trafficking case, next slide, is EEOC versus Global Horizons, again by our LA office, in a case where hundreds of Thai workers were brought in to work on farms, primarily in Hawaii and a couple farms in Washington State. They were promised high jobs, but like in classic trafficking cases, their passports were withheld. They had terrible living conditions. They're threatened with deportation if they complain. And eventually, next slide, please. They were threatened at, yelled at, beaten by supervisors, told they couldn't leave the premises. Again, we brought this as a national origin discrimination case. We got a judgment against Global Horizons a couple of years ago for $8 million. And then we sued some of the individual farms. The Del Monte farms settled for 1.2 million, and the Washington State farms settled for 325,000. There we used a joint employer liability to go after Global Horizons, Del Monte Farms, Maui Pineapple Farms, and then the farms in Washington. Again, no criminal prosecution. The Department of Justice had all this evidence. They knew what was going on. They knew this was a major ring. For some reason or other, no criminal prosecution. And then we have the Signal case. I'm going to be wrapping up pretty soon, which was workers from India brought in to work on ships post-Katrina in the Gulf, in Mississippi and Texas. Again, they lived in modular trailers. They couldn't leave the property. They were charged for their rent and food. It was unsanitary and intolerable. We again brought this as a national origin case, but no criminal prosecution, but a $5 million settlement. Then finally, Henry's Turkeys. This is a very egregious case. This was brought under the Americans with Disabilities Act. Next slide,
Next slide.
please. Next slide. Where 32 intellectually disabled men who were hired to basically clean and cut and gut turkeys had been working for anywhere from a few years to decades. They were issued government IDs, but there were no government IDs, but then locked in rooms, locked indoors. They weren't allowed to leave the premises where they worked, where they lived, which is an abandoned schoolhouse. And then they went to Liberty Foods plant, and they were paid so much to provide. Henry's was provided so much for each worker, and then they did their working at West Liberty Foods. It was a whole scam for the company to get the men's money, their SSI disability payments, etc. Next slide. And then if the workers complained, they were beaten, they were sprayed with hoses, they were knocked to the ground. One of them was handcuffed to the metal beds. They had medical problems that were never taken care of. Okay, these are US citizens, men largely in their 50s and 60s. And for over 30 years, they were hiding, the company was hiding these men in an abandoned schoolhouse. So we brought this as a case of treatment, of different treatment based on their disabilities, violating the ADA. And this case went to trial. Next slide. And eventually, we got 21 men who were eventually part of the class. And then we had an expert talk about how these workers were exploited for their vulnerability because of their intellectual disabilities. Jury came back with a $240 million total jury award. Again, no criminal, state, or federal prosecution. Next slide. So these are the men for whom we try to get relief in this case. Several of them unfortunately have died already. There is a book by a New York Times writer called The Boys in the Bunkhouse, if you want to read about this story. So some of the issues that come up are in proving harassment was a police report filed? Just note that 10% of sexual assault crimes, or less than 10%, are ever reported, and it's probably even less for women who don't speak English. In a case, there are multiple rape cases that we filed in Oregon against Willamette Tree Wholesale. The employer tried to inquire as to why she never complained to the police or never reported the rapes to the police. We obtained a protective order barring inquiry into her immigration status, prior sexual history, and her reasons for not contacting the police in view of the perpetrator's repeated threats to kill the charging party if she reported the rapes. And then, just to clarify the standard in our investigations, it's really not beyond a reasonable doubt, but just civil standard by a preponderance of the evidence. And a classic case is EEOC versus Harris Farms, where the rapes were reported to the deputy sheriff, but the deputy sheriff didn't speak Spanish. Olivia didn't speak English, and the deputy sheriff relied on the credibility assessment of the assistant HR director and said, "All I don't believe her." But fortunately, the jury believed her and awarded her nearly $1 million. All right, so thank you very much.
So, in your, trying to get my video back on. Okay. In the family or civil court cases that you see where abuse or crimes were committed, but there was no criminal investigation, how often do you see that happen? Is it very often, commonly, sometimes, never, etc.? We're getting the poll results in. I'm going to give it a second. And then after we get these results, Bill, we're going to turn back to you for the second part of the presentation. So it's looking to me like, again, trying to do some quick math over almost 70% of you are saying commonly, often, or very often that you see some of these same kinds of facts in cases where criminal prosecutions are going forward. And we'll be talking later on in the webinar about the kinds of things you can do to help provide some remedies for these victims as well. So thank you. We can end the poll and turn it back to Bill Tamayo.
So now the other part that we want to cover is retaliation. So in all of our cases, sexual harassment lawsuits, there's always a retaliation claim. Because people don't come to the EEOC to complain about harassment, they first complain that they were fired. And so what the courts look at is, does the adverse action, meaning termination, demotion, threats, or harm, blah, 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 discourage a reasonable employee to file a claim? So, I tell advocates to make sure you always ask Maria if she was discouraged from making a complaint, who discouraged her, who threatened her. All that stuff is important in order to support that claim. When it comes to immigration status issues, I represented Ms. Castrejón before I joined the EEOC, and the case cited everywhere that undocumented workers are protected by Title VII because because Title VII makes no distinction based on immigration status. And at the EEOC, we will not ask status. We'll fight company inquiries through protective orders, other various motions that we have available to us. And then we can certify for the U visa. I just actually submitted a certification for somebody who in a T visa case. And then if you ever have questions about immigration status or U visas, they should be referred to the regional attorney for any EEOC jurisdiction. And finally, sometimes, we have problems with workers being on time and complaining. In most states, you have to file your charge with the EEOC within 300 days of the last discriminatory act. In this case, Willamette Tree, Emiteria missed her deadline by 62 days because after each rape and assault, the perpetrator threatened to kill Emiteria and her family if she told anybody. And we only got this case because her sister had been sexually harassed and went to the Oregon Law Center asking for help. And her sister Flora says, well, my sister Emmy has not been the same since she was fired. They bring Emmy into the office, and Emiteria describes what happened to her. And we find out she's 62 days late. But I said, we're going to investigate, we're going to file the lawsuit, and the company's going to argue that her case is late, but we're going to tell the court, well, wait a minute, the company can't benefit from having traumatized her so badly that she can't complain. And we got a therapist and a psychologist report to basically inform and educate the judge on how badly Emiteria was traumatized. And the judge granted equitable tolling and allowed our lawsuit to proceed. And we obtained a settlement for her. Thank you.
Thank you so much, Bill. And any of those of you, as before we turn to Mary, who's going to present some more from the EEOC, if you have any questions about this, please type your questions in the chat as we go forward. We will try to answer them during the webinar. And if not, if we aren't able to reach them, we'll provide everybody who's attending the answers at the end, after the webinar with the materials. Over to you, Mary.
Thank you, Leslie. Again, thank you everyone for the opportunity to talk to you today. I had the pleasure of moderating a panel that Leslie and Judge Young were on a few months ago. And Leslie and I talked about this questions and answer guidance afterwards. And when Leslie was organizing this panel, she asked me to be on. I said, wait, you have Bill Tamayo on. I can't possibly add anything after Bill Tamayo. He is one of our experts. But we wanted to share some information about things that a lot of victims might not, survivors of domestic violence, sexual assault, dating violence might not be aware of, and that employers might not be aware of. Next slide, please. So Bill Tamayo had the slide on the laws that EEOC enforces, and these are the categories. And as he said, all of our laws prohibit unlawful retaliation under these EEO laws that we enforce. Next slide, please. And the slides, Title VII of the Civil Rights Act and the Americans with Disabilities Act, in the language, they don't specifically protect survivors of domestic violence, dating violence, sexual assault, or stalking, but the protections against sex discrimination or sexual harassment or sex-based discrimination, and the protections against discrimination based on disability may protect these individuals. And as I said, people might not be aware, the victims might not be aware that they have rights under our laws. The employers might not be aware of their responsibilities, for example, providing a reasonable accommodation under the Americans with Disabilities Act. Next slide, please. So that's why EEOC came up with this question and answer guidance, giving some examples how this might arise. Next slide, please. So for example, maybe you have an employer terminate somebody who's been subjected to domestic violence because the manager fears she will bring, the drama that battered women experience into the workplace, and he doesn't want that drama in the workplace. Or maybe a manager believes that a man can't really be victim of domestic violence, so he does not promote somebody, or he doesn't hire a qualified male applicant after he learns that individual has been subjected to domestic violence. Maybe he thinks that only women can be victims, or the manager might think that a man should be able to resist it. And it's not, again, the status of being a survivor of domestic violence is that he's being treated differently, deprived an employment opportunity, either not being hired, not being promoted, being fired because of his sex, because of the sex stereotypes that the employer has. Next slide, please. Some cases that might pop up, maybe an employer allows a male employee to use unpaid leave for a court appearance as a complaining witness in an assault or a mugging, a robbery, whatever, but does not allow a comparable female employee to use comparable leave for her court prosecution of being a victim of domestic violence. And, it's treating people differently based on their sex in that situation. And sometimes there could be various reasons for that disparity in treatment. You might have a manager thinking that domestic violence is a personal problem or a marital issue, or it's not a crime or not a serious matter. It doesn't matter what the manager's mindset is. We're looking at, is there that intentional discrimination, the disparity in the treatment or the employment opportunities or denial of employment opportunities. And this ties in, this example, I'm sorry, go back one slide, please. Ties in with what Bill Tamayo talked about. You might have a seasonal farm worker, for example. Maybe she's been subjected to domestic violence, living in a shelter. Supervisor knows about it and makes unwanted sexual advances. When she resists, she's terminated. That would be that sexual harassment that Bill talked about. Also, unlawful retaliation. The protections against retaliation include opposing unwanted sexual advances from a supervisor, or it even covers maybe an employee stepping in, intervening to protect a coworker from harassment or assault. If there's an adverse action for that reason, that's a violation. That's retaliation in violation of our statutes. Next slide, please. The Americans with Disabilities Act, again, you could have that coverage. Maybe there's differences in treatment because of disability. An individual, an applicant or an employee, they might have developed a disability, depression, anxiety, post-traumatic stress disorder, other disabilities as a result of surviving domestic violence, dating violence, sexual assault, or stalking. Next slide, please. We give an example. Maybe an employer learns that an employee was a complaining witness in a rape prosecution and suffered depression as a result, went through medical treatment for her. The employer doesn't promote her in this scenario, or doesn't hire her if he learned about it, or fires her because of an assumption that she'll need additional time off for a treatment, take additional sick leave because of the depression. That's discrimination based on disability, which the ADA prohibits. Next slide, please. The Americans with Disabilities Act, in addition to prohibiting discrimination because somebody has an actual disability or a record of a disability, or sometimes an employer might perceive an individual as having a disability, it also requires an employer to make what we call a reasonable accommodation if the applicant or the employee requests it. A reasonable accommodation, it can vary depending on the actual situation, what is needed, but it could be a change in a policy, it could be a modification, it could be use of paid leave, it could be unpaid leave, something that allows an applicant and employee to do the essential functions of his or her job, their job. The accommodation is only for an individual who has an actual disability or a record of a disability. And if the employer is put on notice, the person requests it, or a family member on the employee's behalf, or a healthcare provider, the employer has to provide it unless the employer can prove that it's an undue hardship, significant cost or expense or disruption to the operations. Next slide, please. So we give an example. Maybe an employee has developed depression as a result of being sexually assaulted in her home, or has developed post-traumatic stress disorder. The employee requests a schedule change to allow for seeing a therapist or other medical treatment. The employer refuses it. That would be a failure to accommodate. And in most cases, I think it would be really hard for an employer to show that that kind of schedule change would be an undue hardship, a significant cost, or that disruption to the operations. Of course, we are neutral in the investigation. We would get the information from the individual, the charging party, and ask the employer to provide information. But that schedule change is usually, or unpaid leave, it's usually an accommodation that employers often can provide without it being an undue hardship. Next slide, please. The Americans with Disabilities Act also includes a confidentiality provision that employers have to keep the medical information confidential. So using that scenario from the slide just before, if the employee had asked for time off because of the depression resulting from that sexual assault, if the employer, if the manager, supervisor were to share that information with other people, oh, do you know what happened to Sally? She was assaulted, and shared that personal information, that would be a violation of the ADA's confidentiality provisions. Another way that sometimes employers violate these provisions is by having medical information, what we call commingled in the personnel file. The traditional personnel file has the job description, salary, that kind of information. If they put any request for sick leave or request for accommodations, any kind of medical information or family medical history in that file, that's going to be a commingling that violates the ADA confidentiality provisions as well. Next slide, please. Bill talked about retaliation, and these protections are broad under both Title VII and under the ADA. The Title VII, as our other statutes, protect against retaliation for an employee or engaging in protected activity. The ADA includes the language prohibiting retaliation or interference with an employee's exercise of his or her or their rights, or coercion against exercising their rights under the statute. And protected activity can be very broad. Filing a charge with EEOC, or filing a charge with a state or local agency that enforces a similar anti-discrimination law. It could be being a witness in somebody else's EEOC investigation, be filing litigation under our statutes in federal court, being a witness in somebody else's litigation. If the employer takes an adverse action because of that, adverse employment action because of that protected activity, that's unlawful retaliation. I mentioned it includes the opposing somebody's a supervisor or manager or higher ups unwanted sexual advances. If there's an adverse action for that, that would be a form of sexual harassment. We call that the quid pro quo, or harassment resulting in a tangible employment action. We also say, EEOC says that if an individual requests an accommodation, a reasonable accommodation under the Americans with Disabilities Act, if an employer takes an adverse action because of that, that's also, in addition to the failure to accommodate, is unlawful retaliation under that statute. Next slide, please. As Bill mentioned, there are timeframes, deadlines for filing a charge with us. EEOC enforces also the Equal Pay Act. That prohibits differences in compensation based on gender. Can't pay a man more than a woman if it's based on gender, if they're doing substantially equal work in terms of the skill, effort, responsibility under similar working conditions, or can't pay the woman more than man if sex is the reason for the pay disparity. For that statute, the individual has to go into court. They may file a charge with us, but they can go directly into court. All of the other statutes, Congress wanted the EEOC to have an opportunity to do the investigation and ideally try to resolve it between the charging party and the employer. So individuals have to file a charge with the EEOC first. The deadlines will say under the statutes that the individual has 180 days to file a charge with us. So that could be 180 days from the termination. But the deadlines are extended in most of the states, I think, that we have represented here. If there is a state or local agency that enforces a state or local law against discrimination, then the deadline gets extended to file a charge with us to 300 days. The one little wrinkle, if it's an age case, it has to be a state agency enforcing a state law, then it's the 300 days. But those times can go by quickly. So we're going to be sharing what you should know about filing a charge document with filing a charge with the EEOC in English and Spanish, that if you're inclined, you can share with people that appear before you. Next slide, please. And this is the more information on our website. Individuals can call our numbers to get more information. We have an ASL, American Sign Language video phone. We can take inquiries initially through a digital portal. Right now, we're still teleworking, so we don't have walk-in charges, but appointments can be arranged and the information is there. And next slide, please. You may not see this, I don't know. This wouldn't be maybe as much in some of the trafficking cases, for example, that Bill Tamayo talked about. But I wanted to give a little reminder. There are different timeframes and process for federal employees or applicants for federal jobs. If they think that they've been discriminated against by that federal agency, they first have to go for counseling with the federal agency within 45 days. If it's not successful, then they have 15 days to file a charge. And that's on our website there for federal employees. And when we're talking about these timeframes, again, because with the harassment one, these instances might go on over a period of time. For that time filing period, if there's one instance of harassment within 300 days of the person filing a charge with us, we can go back through all the other instances of harassment. And we counsel and train our investigators and staff about equitable tolling. Bill gave that example. You know, if there's a situation where the employer did that action that deterred somebody from filing a charge with us, that might be a basis for equitable tolling to see about extending. But we always advise people to come forward and file the charge with us as quickly as possible if they can. And I think that's it for my slides, Leslie.
Great. Okay, so we have another poll. Have you been in contact with or worked with the EEOC in your community? I'll give you a few seconds to answer this. And we're going to also try to post the fact sheets that Mary, while you're answering it, that Mary was just referring to.
Thank you, Leslie. And I'll post some links in the chat as well about how to contact local EEOC offices.
Great.
That everyone would have as a resource.
That's great. It's not, I mean, and one of the things that I think it's important, particularly for the judicial officers on the call and people who work in courts, is that the flyers that we're going to be posting, sharing with you, that were just posted from the EEOC, are the kinds of things that courts could include in their Know Your Rights information that get handed out at courthouses, so that people who come to court for other things, but maybe human trafficking, labor trafficking victims, or victims of other kinds of harassment and violations at work, could learn, because they came to court, about what the EEOC is doing. Great.
And thank you for that opportunity to spread the word. And, you know, we never know how it's going to be. It might be, if the resource is there, they might realize they have rights under our statutes. They might realize that a family member, friend is dealing with these situations, share that information with somebody else who needs these resources.
So next slide, Commissioner Young, if you encounter a case where employer may be preventing victims or witnesses from participating in court, what kind of steps might a judge or commissioner or judicial officer be able to take?
Well, I think it's important to make sure that a subpoena was issued. And if you need to, if you find out that you didn't issue a subpoena, if you have to grant a continuance to do so, you should. You can also send a letter to the employer indicating to the employer that the court requires the appearance or appreciate their cooperation.
Great. Okay. We are now going to turn back to Jane to talk a bit about more about some examples of human labor trafficking in prosecutors' cases that she's aware of.
Yeah, because as has been pointed out, labor trafficking hasn't historically been prosecuted criminally very often. And of course, the sort of concurrent crimes and co-occurring crimes as well. So there has been a real push recently by the federal government funding arms to make sure that those of us that are getting funding to work on issues of domestic violence, sexual violence, human trafficking are looking at labor trafficking really intentionally. I'm sure a lot of you have been to maybe conferences or trainings, and 99% of it is sex trafficking. And then it's sort of like, oh, and don't forget, and labor trafficking at the end. And so there's been a real sort of shift. And to accompany that shift, more labor trafficking trainings have been made available. So hopefully we sort of see a movement. I wanted to bring up a couple of examples and how they intersected with the court system. So this is a case example, actually comes from Albuquerque, New Mexico. There were 21 referrals to the Child Welfare Department about these 3 children between 2004 and 2018. Additionally, there were 10 reports to law enforcement about this situation in these children between 2012 and 2018. It was eventually the Attorney General's office has a DOJ funded enhanced collaborative model human trafficking task force, or ECM task force. And part of their funding is to provide some trainings, and they went into the schools, and they actually went into a school where these children were enrolled but were often absent. And when they were in school, they were really tired, they were dirty, and they had sunburnt scalps. So after this training, another report went in directly to the HSI agent or Attorney General agent. I can't remember who it was exactly that was doing the training, but they made a referral right there and then, and that actually prompted investigation. And it revealed that 3 young children were being forced to panhandle to support their father's drug habit. And so what we see here is an intersection with both law enforcement, the Child Welfare Department, dependency court, the school systems, and it really took a lot until somebody sort of looked at this for what it was, which was labor trafficking. The father did go to trial on those charges and was found guilty and sentenced recently out of Albuquerque, New Mexico. The other thing that I think this points out, and if we look at the next slide, it really is to remind us that the relationships between traffickers and victims are often ones that involve family, close social circles, or even intimate partners. So let me take a look at the next slide. We've got another example of how a missing persons report ended up revealing labor trafficking. In this case, it was an 11-year-old girl that was reported missing by, I think, a grandmother. And when they recovered the girl, she actually disclosed, hey, I've been living with this house, several men, an adult woman as well, and that she had been stripping at a local strip club. And in fact, that happened after the people at the house said, hey, if you want to live here, we know you're a runaway, essentially. If you want to live here, then you're going to need to pay your way. And the adult woman, who really wasn't that old herself, was working at the club already. So she introduced the young girl to the club, and she danced several times 100% naked at the club. And so when the young girl was recovered through a missing persons investigation, obviously this is revealed and we start looking at it. And one of the interesting points I want to make from the next slide is that because she was dancing nude and not actually engaging in any sexual activity, when we spoke to our federal partners, they indicated to us, you know what, that's not going to fit under the federal definition of commercial sexual activity. Now, I've since heard that other jurisdictions would maybe have been more broad to that definition, but that's what we were told, that this wouldn't fit under sex trafficking definition. So they were going to have to go under labor trafficking analysis and charge it as labor trafficking, which was an interesting thing because we do see that intersection. But in our case, because I was prosecuting in Florida, we had that carve out not only for labor trafficking for minors, but we also had our definition of commercial sexual activity was broad enough that we felt comfortable charging it as sex trafficking and labor trafficking. So that was an interesting intersection that we see that interconnectedness. And of course, Bill and Mary's examples really highlighted how sexual assault is such a part of labor trafficking. So the next slide is our last case example. This comes out of our criminal and delinquency courts. This is a case that involved several young Hispanic males that were arrested for drug sales. So some of them were young enough that they were still being brought into delinquency court, others criminal courts. Many of these young men were were either themselves undocumented or were from families that had a lot of undocumented family members. So that was a part of the coercion. The young men were all known to work for this gang leader, very known drug dealer in the community, a man named Victor Rax. You'll see the link. We've written about this case extensively. In the next slide, it shows that Victor Rax was well known, and he was actually kind of known as a patron of the community because he was always sort of giving young boys like jobs and money and gifts. And there was this proximity to power that if you were one of Rax's guys, that could be helpful to you and your family. But really what this all was part of a grooming process. And he ended up sexually assaulting those boys and those young men. And then through that assault, he coerced them into drug dealing and part of his drug enterprise. He also used things like cultural fear tactics. He saved, excuse this, he saved their urine, their semen, he cut their hair. He put together shrines to them and made threats that were very real for these young boys. Also included threats of arrest and deportation. And obviously this idea of forced criminality as a form of labor trafficking is probably not something most of us are thinking about right now. So the Utah Attorney General's office, really fantastic work on this case. They saw these young boys, these young men as victims. They actually first did a drug case against Victor Rax. He was in custody without bond. They fought against him being deported because historically he'd been deported and had come back and been back in Salt Lake City. So the victims in the case did not want him deported. They didn't feel safe. So they stopped that. Once there was some safety, they identified 30 to 40 additional victims, and they charged him with those sex crimes and with labor trafficking under the forced criminality idea. And once they did that, Victor Rax actually killed himself in prison or in jail, excuse me, awaiting a preliminary hearing. The judge in the case was really amazing, agreed to hold a hearing on the motion to dismiss, because of course they couldn't go forward with any charges. He had killed himself, but he held a hearing. Many victims appeared and gave victim impact statements. And all of them really thanked the judge for allowing that opportunity because it was so kind of healing and had provided them some closure in that case. So another example of how the victims may come through your courts as well. And so those are those dynamics. And those of you that might be more familiar with maybe gang cases or child abuse cases, you're going to see, right, there's this grooming, this initiation, there may be shame and fear, which is of course going to lead to delayed reporting. All of those same factors are going to be a part of a lot of our labor trafficking cases as well.
Great, thank you, Jane. We're now going to turn to Commissioner Young to bring this home for what this can mean for our judicial office officers on the call. Commissioner
Yes,
Young?
so thank you. In our last segment, we're going to talk about what this might look like from the bench. Next slide. We have two questions. What kind of cases are you likely to see labor trafficking at the state court level? And what can a judge do in response? You might be surprised where you might see these cases. As Jane just said, in drug cases. So we also see in violations and status offenses, as you'll see in one of my example cases, we had a kid who had a loitering and entering a casino underage. And of course, you always see things like shoplifting, curfew violations. So sometimes when you see those, you tend not to keep digging at those. But I think those are a lot of the cases where you find labor trafficking. In civil cases, you see it in protection from abuse. We even see it, I even saw it in a child support case. And sometimes you can see it in a guardianship. So this is the protection from abuse petition. The petition said, he complains when I don't make enough money, and he takes my money and my pocketbook when I get home, and he checks my cell phone. When I first read that, I thought, okay, so this is economic abuse. He's very jealous. He's looking at the cell phone. But next slide. For some reason, there was an answer and a cross petition filed. So the respondent pled, my wife has caused me emotional distress. She abandoned me and our child. She caused us loss of income. that kind of gave me a little reason to pause. And then I read on. So she left me without any notice. I had to buy a burner phone and I searched for her on the Craigslist personals. Well, I don't know who searches for their wife on there. I found that to be a little strange. And then I read on and I was convinced that this was trafficking. I found her with 2 other men who confronted me with a gun, and I went to meet them or meet her, and they told me she's with us now. So he asked the court to issue an order to make her return home, and he sought custody of the child and compensation for his lost family income. So when we talk about what can we do, I immediately thought, well, I'm going to have these 2 people in the courtroom. I'm not going to be able to speak openly about this. So I contacted one of the victim advocates and said, can you please make contact with this person? I think this looks like trafficking to me. But the PFA ended up getting dismissed because neither party appeared for the trial. So things, that the court can do: contact the victim advocate, as I said, have them explore some social service supports to encourage autonomy, help them to break the chains with this person. Being proactive is not giving legal advice. It's not overstepping. It's not going to the merits of the case. And encouraging education of your fellow judicial officers and agencies, constituent agencies. Know where victims can get help in your area and helping to direct them. So the victim advocate, or mentioning to a victim, you might want to contact community legal aid. A lot of churches have programs, or other NGOs. U.S. Department of Justice and Health and Human Services. There's a lot of handouts that you'll see in the links at the end of this presentation where you would be able to find things like that. Get to know your human trafficking task force and the members. Go to the Blue Campaign website. This is for training, for materials, information, and educational materials, and victim assistance handouts. Next slide. So another PFA, and that's a protection from abuse order. And this is one that was very early on, and it kind of underscores the importance of education. So this was an arranged marriage, a non-citizen, and she was expected to produce children, cook, clean, and she didn't have any freedoms. So she wasn't allowed to go out of the house, go shopping. She was not permitted to have a driver's license. She didn't even have an ID. She was humiliated and abused by the mother-in-law. Her application for citizenship was held up as part of the leverage. The wife sought no contact with the husband and the in-laws, temporary spousal support, and custody of her children. And so this, next slide, this PFA at this time to me looked like extreme domestic violence. I did not see it as labor trafficking, which it was. I signed the U visa cert, but had I recognized it that it could also be labor trafficking, I probably would have suggested to the attorney, have you considered filing a T visa too? Because as you'll see in the in the supports after this presentation, there's a lot more relief under the T visa. So even though she only got a U visa, I was happy to see her. I really didn't think anything about it because I wasn't thinking about her nonstop, but she came to the courthouse several years later and said, "Do you remember me?" And of course I did not. But then as soon as she told me, I was the lady who was kept in the basement during the day when my husband would go to work, I remembered. And she said, I got my citizenship and I have a job and I went back to school, and she had custody of her kids. But that was a case that because of lack of education, I didn't see it as that. And the attorney didn't see it as that. Neither one of us saw it as that. We just thought, oh my, look at this. This is terrible domestic violence. So I also had this in a child support case. And this was a Delaware resident. He was completely unaware that he had been trafficked. And he just considered this a bad deal. So I filled in for somebody else. I went in to do a child support arrears. First case on the calendar. I said, have you been paying your child support and have you been employed? So he told me his whole story. He said, no, I'm unable to pay because I answered this ad in a magazine for solar sales. And they told me that they would send me out to the Midwest. He said they agreed that I would get housing, salary, bonuses. I would have my own crew. So he was taken to Ohio, but he wasn't paid as he was promised. He was kept in some rundown building and it was dirty. He said he was afraid to lay down at night that mice were going to get in his clothes. He was threatened when he tried to leave, and he made several attempts before he was actually successful in hitching a ride and going to the bus station, and somebody bought him a ticket. But he was unable to return to Delaware for 5 weeks. When I suggested to him that he should contact the Department of Justice, he, like a lot of victims, he wanted to just move on. He wanted to forget about this. It was a very bad experience. He considered it a bad deal, but he did not see the criminality of it. Next slide. Oh, this slide was out of order. This goes to the lady who was kept in the basement, the labor trafficking case that I didn't really see at first. So as I said, what else could I have done? Like I said, if I had been better educated at the time, I would have recognized that. But I did make a detailed finding in the other, and I detailed my findings of fact as to why that was, why I was issuing the order. You know, it was also put on the record. She did a very good job of testifying, and she was very well supported by community legal aid and a victim advocate. So how can judges make ethical and valid suggestions to counsel? Like I said, in that case, I could have said, I'd be happy to sign your U visa, but have you considered maybe a T visa? Or sometimes counsel doesn't recognize a trafficking situation. You might bring them to sidebar. You can always talk to the AG at sidebar if it's a criminal case. But civil counsel, you might ask them, have they considered that maybe their client needs additional supports, and make a suggestion they contact either community legal aid or one of the pro bono attorneys. So the next slide. So this was the child labor trafficking case, and it looked like entering a casino underage and loitering, because that's how it came in. But this was really labor trafficking. And I didn't know that, I think he was 18. I don't know why that came to family court. Because the police officer actually knew he was 16. So it looked like he was 18, but he actually was 16. So there was some fraud in getting his identification that the trafficker arranged. So this young man was recruited from a jockey school in Puerto Rico. The trafficker was his agent. He was also his guardian because he was a friend of the parents, and the parents gave him guardianship of this child because the parents thought that this was going to be a great experience for him, that this kid was going to be able to ride the big racetracks on the East Coast. He was going to make some money, get exposure, and to start his career. And this kid was working excessive hours. So he was working as a jockey, as an exercise rider, as a groom. It's kind of like asking an executive chef to also be their own prep person and be the dishwasher. It was just unbelievable amount of hours. And there were other boys too that were under the same situation. They were living in poor conditions. Their work conditions were also terrible. You know, it's very hot. They're outside all day, up late at night. This young man thought that he was coming to the East Coast just for a short time for the summer. He intended to go back to school in September, but he ended up being stuck because the agent kept saying to him, you owe me, you still owe me money. You're in the hole. He had to work to pay licensing fees, housing expenses, agent fees, management fees, transportation, food, equipment fees. And some of the threats were, you'll never work at the big tracks again. Your parents will be disgraced. Your career will be ruined. So he stayed in this situation, and he did not even, he was not interested in any kind of other prosecution. He just wanted to go home. So another thing that you might see, I did not put this slide in here for some reason, is in guardianships or custody. So when you're doing guardianships or custody, you have to make a best interest determination, and most states have a statute that guides that. Delaware does, and enumerates the factors. This puts you in a great position to ask about a child's daily routine. Are they going to school? What kind of progress are they making in school? What kind of grades are they getting? What is their schedule? Who takes them to do their school shopping? Do you have family outings? Do you have dinners? Do you have family get-togethers? And you get a chance to look at the kids. What do they look like? As Jane was saying, you know, there were some children that were observed at school, obviously outside in the conditions. So are these children clean? Do they look well rested? Do they look well cared for? Are these kids doing kid things? So I've discussed this with colleagues and saying like, hey, you should really be looking at some of these factual issues in these cases, because this could be a trafficking situation undercover. You don't know it. And they often, they feel like, well, I don't know, the feds did some deep backgrounds on these people before they release them. And I don't know what the actual process is. I don't know if they do a deep background search on people, you know, extended family members that children are released to. And you can't really count on that. So I think the court should be the safety net, make sure that you go through that. Appropriate judicial responses. You know, you can call a child abuse hotline, get that victim advocate, talk to the DAG and the defense at sidebar, talk to your trafficking unit or your special prosecutor, contact your human trafficking counsel network, but do nothing is not the appropriate option. Next slide. Those Know Your Rights publications in your courtroom and in your self-help centers are invaluable. Utilize your victim advocates to reach out and make referrals to agencies and assist people with exploring options and services. I think the courtroom is a pretty intimidating place to start talking to people about are they being trafficked, or could they apply for some immigration relief? So there's a lot of other options that you have. Step up, play a leadership role in your court. Discuss projects with your court administrator and your chief judge to create groups and task forces, and to be a part of committees, to partner with other key agencies. And I want to give a shout out to my chief judge for being so, Michael Newell, for being so supportive of all of our efforts. Enhance victim access to justice by continuing to hone your skills to be able to detect trafficking and protect these vulnerable victims. I think that's the end of my slides. Oh,
Thank
we
you,
have a
Commissioner
poll.
Young. I have one question. In some of these cases, particularly, would you be able also potentially to appoint counsel, like if people are pro se, and some, is that an option that judges might consider as well?
Yes, and some of in the guardianship and custody matters, certainly you can appoint counsel guardian ad litem for the child.
Thank you.
And
So,
just bringing that to the attention of defense counsel, our defense counsel is a very strong and active bar. And I have discussed that numerous times with attorneys and said, like, you know, that was so funny to me. Have you looked into that? That, you know, you're making sure that child is safe, or and they do have, you know, with the psychoforensic interviewer and other staff in their office, they do talk to the child about those things and, you know, make referrals, or, you know, they've made hotline calls themselves.
great. So we're going to kind of begin to draw to a close with a poll. And so the poll is, after attending this webinar, the next time you encounter a labor trafficking victim, check all that apply. Will you be able to identify labor trafficking victims in the cases before you? Connect potential victims with resources and legal rights information. Make findings that document labor trafficking so that if the victim, you know, so the victim has a record that they could use potentially in proceedings, immigration proceedings being an example. And craft orders that provide relief to victims. I'll give you a few seconds. While you're answering that, Jane, can you tell them a little bit about the resources on your website? We'll show the slide in a minute.
Absolutely. Equitas has a lot of public facing resources that are really developed to provide a lot of background information and help those folks that are doing this work on a day-to-day basis. So some of the things that might be of interest is the use of expert witnesses. I know Bill talked about how that was really helpful in one of his cases. We also can connect you with the 5-part labor trafficking series that was recorded last fall when we sort of translated our 2.5-day training to a virtual training series. It's hosted by the International Association of Chiefs of Police. So it's on their website, and I'm happy to give you that link as well. We also have a lot of resources for prosecutors that are maybe a little hesitant to work on cases that involve U visas and T visas. These are usually novel issues. They might be working in small offices or even larger offices where folks just haven't dealt with it before. Just like judges, you know, this isn't something that comes up every day, and it can be really daunting. So we have a lot of services so that those prosecutors who are making those decisions to charge and go forward with some of these crimes are feeling a little bit more confident that they've got those resources and support.
Wonderful. Thank you. And next slide, please. This we have Jane's resources here. Oh, whoops, they got in a different order. Can you go back? I think you skipped. I don't know. Okay, so Jane's resources are here. Everybody who's on the webinar will receive a copy of the slides with all the links and information. There's also helpful information from the EEOC. Next slide. That we'll provide you as well, including, and we'll include in the information we provide you how to contact your local EEOC office. And then NewApp also has lots of information available for you. Please fill out the evaluation of the webinar. It will be very helpful for us to plan in the future. If you're a judge or commissioner or magistrate or judicial officer, please consider joining the National Judicial Network. And we're going to have an upcoming webinar on immigration options for survivors, talking about SIJS and U visas. And in conclusion, I can't thank from the bottom of my heart all of the presenters who've come to share their expertise today. I think this has been a really enlightening webinar, and we hope, and I'm going to let Bill Tamayo close us out.
I just want to say one thing too, is just for the judges. I mean, I've been on top of these investigations, on top of the litigation. I've signed off on U visa certifications. So if you're having trouble on like, how do you look at these cases? How do you properly assess credibility? Contact me, you know. 6 years ago, Leslie and I trained 200 U visa adjudicators at the Vermont Center on how to properly exercise their discretion in determining, whether this is a valid U visa application or not, whether the certification's valid, et cetera. And that's the first time they had heard from somebody from the civil side who'd been signing off on these matters. And so it's really use me as a resources, and you have all my contact information there too.
Great. Thank you, Bill.
Thank you.
And thank you to all the presenters, and I'll make contact information available for everyone. And I can't thank you enough for your time and attention, and we're here to help you. If you get a case and you think it's labor traffic and you want to check in with us, you can contact NUAP and we can connect you not only with Bill and Jane, but we have a team of prosecutors, a team of judges nationally who do training and technical assistance, and a team of law enforcement officials who do it as well. So we're here to connect you so that you can get the information when you need it in a timely manner, so that it can help you think creatively about how you can step in and help immigrant and non-immigrant victims of labor trafficking. So thank you so much. Bye, everybody. Have a good week.